Democrats have said it's a dangerous and tone-deaf policy that's hidden in legislation aimed at improving school safety.
The Second Amendment to the United States Constitution, Mr. President, as you well know,
that I'm working with the National Association for Gun Rights to bring legal action against the ATF.
And what I hold dear is that I trust the people of the great state of Florida a whole lot more than I trust the government.
The ATF has a history of reinterpreting federal law in an attempt to expand what firearms accessories are illegal.
People thought that the federal government would never be able to get a gun law bill passed again. They got one done in the last year.
As a result, there are differing opinions on whether Rare Breed's Force Reset Trigger qualifies as a mash gun for purposes of the GCA and NFA. Florida Senate approves bill to abolish concealed weapons permits. A bill to abolish concealed weapons permits has been approved by the Florida Senate, enabling gun owners to carry weapons in the state without the prior prerequisites of a license and training. Republican officials, including Governor Ron DeSantis, have endorsed the proposal, suggesting that the legislation shouldn't have any trouble passing in a legislature controlled by the party. Democrats, however, have claimed that the plan would lessen safety in Florida, a state known for its tragic mass slayings.
Democrats have said it's a dangerous and tone-deaf policy that's hidden in legislation aimed at improving school safety.
Is it the most robust, far-reaching gun law in the history of the world? It is not.
Carry concealed weapons without a permit or without any sort of training has passed in the Florida legislature.
Supporters of the law refer to it as constitutional carry, but opponents refer to it as untrained carry, since it will allow people to carry firearms without the necessary background checks and training. Despite Florida's lack of a permit requirement for gun purchases, gun owners must still apply for a license to carry a concealed weapon, which at the moment necessitates a special background check and training. The Florida Department of Agriculture estimates that over 2.5 million Floridians have gotten a permit to carry a concealed handgun. The recently proposed law, however, would do away with the requirement for these concealed carry permits, enabling Floridians, as well as non-Floridians who satisfy Florida's qualifications, to carry concealed firearms in the state without having to submit an application. According to the proposed legislation, gun owners who wish to carry a concealed weapon need simply have a valid ID on them at all times. The current laws prohibiting the purchase of actual firearms would not be affected by the proposed legislation. Thus, individuals who are already forbidden from doing so will continue to do so. The state's existing list of prerequisites, which currently includes a 21-year-old minimum age to purchase a firearm, would remain in place. On March 24, the Florida House passed the legislation with a 76-32 majority. The Senate will now review it. By a vote of 27-13 on March 30, the Senate approved the legislation, advancing it one step closer to Governor DeSantis' desk, who has already indicated his intention to sign it. Local authorities, elected officials, activists, and the relatives of gun violence victims have voiced their perspectives on the proposed legislation from both sides of the political spectrum. The motion was described by Speaker Paul Renner as a universal right that applies to each and every man or woman regardless of race, gender, creed, or background. Democrats contend that the law might exacerbate Florida's current problem with gun violence, and local gun control advocates and victims have voiced their opposition to the proposal. Sheriff Wayne Ivey of Brevard County and Bob Gualtieri of Pinellas County contend that law-abiding residents have the right to self-defense without the need for a permit. Comparing Florida's gun laws to those of other states, it is noted that nearly half of the nation currently permits permitless carry. If the legislation is approved, Florida will join states like Texas, Georgia, and Alabama in eliminating concealed weapons permits, making it the 26th state to do so. In an effort to further control who is allowed to carry a concealed firearm in public, New York has attempted to enact rules. A New York legislation requiring citizens to prove a specific reason for carrying a pistol in order to obtain a license to do so in public was overturned by the Supreme Court in June 2022. The New York law, according to the ruling, infringed the Second Amendment right to keep and bear arms, which increased gun rights worldwide. Mayor of Omaha City Gene Stothert issued an executive order banning the possession of weapons on city-owned property. Starting this week, signs will be put up on such sites. The ordinance forbids the carrying of guns on land that the city owns, leases, or manages, including structures, facilities, parks, and open areas. The executive order does not apply to law enforcement officers, trained security guards employed by or under the direction of a government entity, or those who have received Police Chief Todd Schmatterer's prior consent. Nebraskans who are 21 years old and older will be able to carry concealed guns without a permit under Senate Bill 77. City Council President Pete Festerson is considering additional steps through ordinance, such as controlling ghost weapons and high-capacity accessories, as well as safeguarding public properties. He supports the mayor's executive action. The city must repeal its own gun rules, according to Municipal Attorney Matt Cusey, because the relaxation of gun prohibitions will certainly lead to an increase in demands to the police that they are unable to fulfill. According to Festerson, the relevant city's gun laws contributed to the removal of 1,400 illicit firearms from the streets in 2017. If the cases haven't been concluded in full, those who have been charged under the firearms restrictions that were repealed will have their charges dropped. Nebraska's LB 77 constitutional carry law and local responses. On September 2, Nebraska's LB 77 permitless concealed carry law went into effect. The law was implemented statewide and nullified a number of regional firearms laws. In response to the ordinance, the city governments of Omaha and Lincoln have taken action to prohibit weapons in public areas. Before, obtaining a concealed carry permit meant passing a criminal background check, forking over $100, and enrolling in a program for 8 to 16 hours on gun safety. Measures like LB 77 are frequently referred to as constitutional carry because some gun rights activists think that people have the legal right to carry concealed weapons without a permit under the Second Amendment of the U.S. Constitution.
The Second Amendment to the United States Constitution, Mr. President, as you well know,
that I'm working with the National Association for Gun Rights to bring legal action against the ATF.
gives private citizens the right to possess a firearm, including a pistol.
Since assuming office in 2017, Gordon State Senator Tom Brewer, who introduced the measure, has been working to adopt legislation resembling LB 77. The measure was praised by Brewer, who declared that Nebraska's laws are about to more closely resemble our Nebraska values. However, LB 77 was one of the legislative session's more heated discussions, with strong comments coming from both sides. Local governments and law enforcement organizations had differing opinions on the bill. An executive order prohibiting weapons on city-owned premises was made possible by the opposition to LB 77 from Omaha Mayor Gene Stothert and the majority of Omaha City Council members. Because LB 77 rendered 22 city firearms laws illegal, the council decided to repeal them and change 8 other laws. Brewer predicted that Omaha and Lincoln will be most impacted by the new law. Government, Military, and Veterans Affairs Committee legal counsel Dick Clark asserted that both municipal and private property owners have the ability to prohibit the carrying of firearms inside such premises. When it comes to open public areas like parking lots or parks, he is unsure of how the directives will fare legally. NRA representatives are already researching their legal options in response to the Omaha mayoral order, and litigation may be brought. LB 77 does not alter who is permitted to acquire firearms in Nebraska. However, it does allow persons to continue applying for concealed carry permits if they so choose. Senator Jane Raybould of Lincoln, one of LB 77's most vocal opponents, thinks the legislation will increase gun crime and has already made some locals feel less secure. The majority of Nebraskans over the age of 21 can now carry concealed guns without the permit, thanks to a law that was approved by the state's legislature and went into effect on Saturday. Senator Tom Brewer of Gordon is a sponsor of the constitutional carry measure, which declares unconstitutional any local laws that restrict Nebraskans' ability to own, store, transport, sell, or transfer weapons. The measure invalidates a number of the city's gun-related laws, including the short-lived city rule that for the previous 4 years had mandated that people who keep firearms in their cars keep them locked and out of sight. It does, however, permit landowners to forbid concealed carrying on any property under their control. An executive order was signed by the mayor, Lirion Gaylor Baird, to lessen the effect of the measure on city property. Similar instructions were given by Omaha Mayor Gene Stothert. The two orders collectively forbid carrying guns into city property in the 2 largest cities in Nebraska. Guns are still not allowed in city buildings, public libraries, or parks, according to a recent release from city officials in Lincoln. The Lincoln-Lancaster County Public Building Commission has banned numerous weapons, not just firearms, from its premises. Guns, tasers, knives with blades longer than 3.5 inches, any devices that fire propelled objects by a spring mechanism or compressed gases, and other illegal goods intended or likely to cause demise or serious bodily injury are forbidden from being brought into public venues. Law enforcement facilities, jails and prisons, courthouses, polling locations on election days, and meeting locations for any public governing body, including the legislature, are still prohibited by state law from allowing gun owners to carry weapons within. Aside from these places, state law also prohibits the use of guns in banks, professional or semi-pro sporting events, public and private schools, as well as school athletic activities, churches, hospitals, and political rallies and fundraisers. Residents are also prohibited from carrying hidden weapons when using drugs or alcohol, or right after. It would be a Class 3 misdemeanor for a first offense to carry a hidden weapon onto a premises where such weapons are prohibited, or while under the influence of drugs or alcohol, and a Class 1 misdemeanor for any subsequent violations. The new law does away with the prior mandate that concealed handgun carriers complete training, but it does give gun owners new obligations. Anyone in the state who carries a concealed handgun must also carry personal identification, such as a driver's license, a state or military ID card, or a passport, and must show this documentation upon request from law enforcement or emergency personnel. When approached by law enforcement or other first responders, such as during a traffic stop, someone carrying a handgun must also promptly inform them that they are in possession of a concealed firearm. The measure also changed a criminal statute in Nebraska that had previously prohibited non-permit holders from carrying any deadly weapon, such as guns, knives, and brass knuckles. The law now covers juveniles and prohibited individuals who are frequently prohibited from possessing weapons due to prior felony convictions. Additionally, carrying a weapon or destructive device while committing a dangerous misdemeanor became a crime under Brewer's measure. The following are examples of dangerous crimes as defined by the law: stalking, domestic violence, shoplifting, and resistance to arrest. A Class 1 misdemeanor will be charged for the first and second offenses of that newly defined statute, and a Class 4 felony for the third and subsequent offenses. A Class 2 felony is committed when a firearm is present during the conduct of a crime, whether it is concealed or not. Controversy surrounding forced reset triggers and legal battles. The forced reset triggers on AR-15 style rifles have sparked controversy among gun enthusiasts, with the Federal Bureau of Alcohol, Tobacco, Firearms, and Explosives declaring them illegal mash guns. Rare Breed Triggers, founded in Florida and now based in Fargo, North Dakota, claims that the ATF was wrong and kept selling its FRT-15 triggers, setting the stage for a legal battle in federal courts in New York and Texas.
The ATF is trying to set the groundwork to ban all semi-automatic firearms by redefining what a semi-automatic trigger actually is.
People thought that the federal government would never be able to get a gun law bill passed again. They got one done in the last year.
The triggers are the latest rapid-fire gun accessories to draw scrutiny from government officials worried about mass slayings and police officer safety. Rare Breed Triggers denies any wrongdoing and is currently being heard in federal court in Brooklyn. The National Association for Gun Rights sued the ATF in a federal court in Texas this month, challenging its classification of the FRT-15 as a mash gun. Both the bump stock and forced reset legal battles involve how to apply the National Firearms Act of 1934, which bars the public from owning mash guns. On the firing range, guns equipped with either bump stocks or forced reset triggers certainly look and sound like mash guns. In court filings, the ATF said testing on the FRT-15 triggers showed their rate of fire can meet or exceed that of the military's M16 mash gun, which can fire 700 to 970 rounds a minute. However, under the law, the key to whether a part turns a weapon into a mash gun isn't the rate of fire, but what kind of human input is involved in firing multiple rounds. Rare Breed's owner, Kevin Maxwell, and its president, Lawrence DeMonico, both appeared in federal court in Brooklyn this month to argue their device is not a mash gun because it forces the trigger to return to the start position after each shot, satisfying the requirement of one function per round. The ATF has issued a temporary restraining order in January barring Rare Breed from selling more of the triggers while the legal dispute plays out. The binary trigger, which allows a weapon to fire one round when the trigger is pulled and another when it is released, is legal in most states and at the federal level. The binary trigger and bump stocks work differently than forced set triggers, and the federal court in New Orleans that ruled bump stocks weren't an illegal mash gun conversion noted the decision didn't apply to certain types of devices equipped with springs or other mechanics, helping shooters fire automatically. Legal controversy surrounding Rare Breed triggers and Nager versus Garland. The difficulties of U.S. triggers against Rare Breed triggers, as well as Nager versus Garland triggers, will be the primary focus of our attention. The new attacks that Homeland Security has made on force reset triggers, as well as the two conflicting orders from federal courts that have received in the span of just the past week. Now, for this specific issue in these instances, we need to go back and cover a lot of ground so that you guys understand where these lawsuits are coming from and what is occurring with the ATF. They are coming under fire once more for these particular triggers, but this dispute between the ATF and this one firm over Rare Breed triggers has been going on for years. Back in July of 2021, the ATF sent a letter to Rare Breed triggers demanding that they stop their illegal activity. The ATF stated in the letter that in their opinion, the triggers violated the law that they should not be used. Recently, Ruby Triggers joined forces with Nager, an organization that operates in two directions, and the three of them filed a complaint against the ATF in the Northern District of Texas.
Colleagues have no problem with the ATF going outside its boundaries.
The ATF has a history of reinterpreting federal law in an attempt to expand what firearms accessories are illegal.
The case was subsequently forwarded and given to Judge Reed O'Connor, who is also the judge reviewing the ATF's assaults on pistol braces as well as frames and receivers. The case is currently being reviewed by Judge Reed O'Connor. However, at the same time that all of that was going on, there was also a Rare Breed FRT-15 that had a force reset trigger that met the NFA, and the government also asserted that Rare Breed was engaged in mail fraud, wire fraud, making threats to the ATF and federal courts, and engaging in other types of improper activity. In their case, the government asserts that Rare Breed triggers illegally continued to sell Rare Breed triggers and WOT triggers, despite the fact that the Rare Breed Corporation had previously prevailed against Big Daddy Unlimited in a patent lawsuit. Rare Breed Triggers is accused by the government of engaging in unlawful sales of WOT triggers and concealing those sales by failing to indicate on the outside of the packages that they originated from Rare Breed Triggers. This is one of the allegations made by the government. According to the allegations made by the authorities, the business allegedly sold approximately 3,500 of these triggers using this method. There were also some allegations that an anonymous caller had threatened the ATF, specifically that they threatened to come down to the ATF office and participate in some kind of criminal action. These allegations were included in the complaint. The ATF claims that they were able to monitor that phone call and determine that it originated from the initial phone number associated with the law firm of the defendant Maxwell. Allegations and legal developments in Rare Breed Triggers cases. There were also other allegations that were mentioned suggesting that during the initial litigation in Florida, there were phone calls and threats made to the judge in the Florida case. In addition, it was alleged that the ATF had issued a warrant for the search and seizure of the triggers, and that the defendants sought to remove the triggers from the facility in order to prevent the ATF from carrying out their search and seizure. Accordingly, the New York case contains a great number of accusations leveled against the firm. Given that the government is the one making these accusations against the corporation, it is essential to examine them with extreme caution. On the basis of these claims, the government initially made a request to the court for a temporary restraining order, in which they asked the court to prevent Rare Breed Triggers from selling their wares. The TRO was granted by the district court in New York. After that, it was anticipated that the court in New York would also rule in favor of the ATF and grant a preliminary injunction in their favor.
The measure now heads to the desk of Governor DeSantis, who has said he would sign it.
And what I hold dear is that I trust the people of the great state of Florida a whole lot more than I trust the government.
The court's decision to approve the government's request for a preliminary injunction was confirmed in the form of an order from the court. Within the most recent order, the court declared that, on the present record, the court concludes that the government is likely to succeed on the merits of its claims. The court went on to point out that the defendants had sold approximately 100,000 unlawful mash gun conversion devices throughout the U.S. These devices are known as FRT-15 triggers, and they generated $39 million in revenue from their clients in less than 2 years. The court went on to add that the defendants committed fraud against their consumers by misleadingly asserting that the FRT-15s were completely lawful while concealing material facts that proved they were not legal. This caused the customers to purchase a device that it is against the law to possess. As a result of the defendants' actions, tens of thousands of their clients were put in jeopardy of facing criminal charges and having their right to possess firearms taken away from them. Even after federal officials informed the defendants that they were engaging in the illegal sale of weapons, the defendants continued to employ fraudulent ways to sell thousands of FRT-15s and obstructed law enforcement's legitimate efforts to monitor and retrieve these devices. As a result of this, the U.S. District Court for the District of New York agreed to approve the preliminary injunction requested by the government against rare breed triggers. On the other hand, a federal judge in Texas named Reed O'Connor ruled in favor of the plaintiffs in their complaint against the ATF and granted a TRO. It is crucial to comprehend the distinction between a TRO and a preliminary injunction in order to comprehend what is taking place in these two instances. A preliminary injunction continues to be enforced for the entirety of a case until it is decided on the merits, whereas a TRO, which is generally issued on an emergency basis, is granted for a significantly shorter period of time and can often only last for 14 days. Consider a TRO to be a stopgap measure until the stage of the lawsuit is reached, where a preliminary injunction will be heard. A TRO was issued in favor of the individual plaintiffs in the O'Connor order. In his ruling, Judge O'Connor makes reference to a decision from the Fifth Circuit Court of Appeals called the Cargill decision, which addressed the question of whether or not bump stocks were mash guns. He decided that the plaintiffs have met their burden of proving a strong likelihood of victory on the merits of their claim, because the recent study that the Fifth Circuit conducted on the particular legislative language that is at issue here reveals that they have done so. The defendants, in this case the ATF, have not provided any rebuttals as to why Cargill should not govern in this matter. The only thing they have done is present a single footnote with a simple conclusionary statement to that effect. Differing circuit court opinions on the Cargill decision and implications. In the matter of the bump stock, a district judge in the Columbia Circuit disagrees with the decision that was handed down by the Fifth Circuit in the Cargill case. The judge continues by stating that apart from this reference, the defendants do not present any analysis explaining why the court should deviate from the precedent set by the Fifth Circuit to adopt the logic and guidelines. Instead, the defendants have promised that their future briefing at the preliminary junction stage will explain why guides, rather than Cargill, should govern this situation if the case proceeds any further. Again, this is not the case because Judge O'Connor is constrained by the decision that the Fifth Circuit Court of Appeals made in the Cargill case. As a consequence of this, he decided to issue a TRO in favor of the individual plaintiffs in this case. It is essential to keep in mind that this TRO only provides limited protection to the individual buyers and possessors of these triggers, and it will remain in effect until a decision regarding the preliminary injunction can be made in this particular instance. In light of all of this, how should we essentially choose between the two options that are available to us? Because these triggers are regarded to be mash guns, a court in New York has decided that rare breed has broken both the National Firearms Act and the Gun Control Act. In the meantime, a different district court in the state of Texas cites the decision made by the Fifth Circuit in Cargill and provides limited TRO protections to some plaintiffs. In the end, these seemingly incongruous verdicts will almost certainly be appealed in the near future, with the New York case having the potential to be the first to be reviewed by the appellate court. However, there is a chance that the Supreme Court will be required to revisit these cases, particularly in light of the fact that the court is now hearing arguments in the Cargill case. If the Supreme Court decides to hear an appeal in the Cargill case, it will have a direct impact on the actions that the ATF can take regarding force reset triggers. This case is particularly noteworthy due to the fact that we obtained two different rulings within the span of just 1 week on what constitutes a mash gun and whether or not the trigger force satisfies the definition of a mash gun.
And other similar force reset triggers are not machine guns as defined by federal law.
And sometimes elected officials will act and sometimes they won't across the country.
By January 13th of 2021, The ATF had launched an all-out assault on us.
That's all for this video, folks. Thank you so much for watching today, and we will see you next time.